Hello, everyone, and welcome to the third, and dare I say at best, webinar for the 2021 The Year in Review series. Today's presentation is on the topic of human rights. During the month of November, Fasken's National Labour, Employment and Human Rights Group is hosting webinars for our 2021 The Year in Review series. Our next webinar takes place on November 23rd on the topic of labour relations. For those who do not want to suffer from FOMO, please visit Fasken Institute in the section on the fasken.com website to watch past recordings or to register for next week's webinar. My name is Erin Porter, and I'm sorry to disappoint all of those who are hoping to hear from David Wong today. Unfortunately, David has lost his voice. I'm not going to start the rumor that he was singing in the shower too much, but you can come to your own conclusions. And so I've stepped in to take over presenting his materials. In addition to being David's understudy, I'm also the vice chair of the Ontario LEHR group and a partner in the Toronto office. I am joined today by my fellow LEHR colleagues, Rhonda Grintuch from our Montreal office, a partner out there in Quebec, and then Bonny, one of my partners here in the Toronto office. Before we begin, I'd like to start with a few housekeeping notes. Underneath the video window, you will find tabs for the handout and the survey. At the end of the webinar, we'd appreciate your feedback via survey. If you have any negative feedback, I think it's only fitting that you attribute it to the fact that David is absent. Questions? Please submit your questions via the chat box. We'll do our best to answer all of the questions that we can. Closed captioning. If you would like to turn on the closed captioning feature, please use the CC button at the bottom of the video window. If you require technical support, please click the tech support button. If you are looking for COVID-19 specific information, we have a wealth of information in our COVID-19 Knowledge Center, which can be found again at fasken.com. With that, on to our presentation. Here's a quick overview of what we'll be speaking about today. So vaccines and the grounds of religion, disability, and political belief. Bonny will then speak about mandatory vaccination policies, unlawful discrimination versus the legitimate enforcement of rules. Next up will be Rhonda talking about the fact that language matters and discussing pronouns and discrimination. Then we'll come back to me to talk about systemic discrimination. Bonny will speak about family status discrimination, and then Rhonda will finish us off with the continuing trend of increasing human rights damages. So starting with vaccines and the grounds of religion, disability, and political belief. As you know, each province has its own legislation that sets out the obligation to not discriminate. Although it varies slightly from region to region, the idea is generally the same. For example, in Quebec, they have the Charter of Human Rights and Freedoms, and that legislation protects against discrimination on the basis of disability and freedom of religion, as it does in many other provinces, but it also talks about protection based on personal liability. The personal liberty. The personal liberty section of this act has been used by some to try and justify the right not to receive a vaccine, saying that they have a right to refuse to put anything into their body that they don't want to. Under this legislation, there's a section 9.1, that allows for a defense stating that a fundamental freedom and right, a person shall maintain a proper regard for the democratic values, state laicity, public order, and the general well-being of citizens of Quebec. So to meet this test, you need to demonstrate that it's neither irrational nor arbitrary, and that the means chosen are proportionate to the overall aim pursued. Next, moving on to Ontario. So in Ontario, we have the Human Rights Code. Here it protects against disability and creed. Creed isn't defined in the code, but it's often analogous or similar to what would be a protection on the basis of religion. In order to meet or to qualify for protection based on religion, it has to be a sincerely held belief that is integrally linked to a person's identity. It's a particular and comprehensive overreaching system that governs one's conduct and practice. And it has to have some sort of nexus in an organization. So it's a shared belief, not an individual belief. And it's actually quite interesting. I think this is the first time that I've been aware that human rights commissions across the country have been releasing statements about COVID and mandatory vaccination policies. So the Ontario Human Rights Commission came out with a statement indicating that mandatory vaccination policies are generally permissible. And so they say that it's fine as long as you allow for exemptions. And those exemptions could be based on again, the creed or based on disability. And in the policy statement that they put out, they spent most of their time focusing on the medical reasons. And so they said that, it has to be a specific reason from a doctor, it has to be a written statement. And the Ministry of Health has followed up on this, and they've put out a statement indicating that exemptions based on a medical belief to receiving the vaccine should be fairly narrowly construed. So they've got a list of things, and most of it is around, if you have extreme or severe allergic reactions to some of the components, you had trouble with the first vaccine, things of that nature. So it's much more narrowly defined than what we would have seen medical exemptions being in the past. And then at the very end of that document, they kind of put in one little statement that says, and with regard to accommodations based on creed, we should point out that personal preferences and singular beliefs are not protected. And the commission went so far as to say they're not aware of any court or tribunal that has recognized a request to deny vaccines on the basis of creed. So they've almost put out this bat signal saying we're not going to be that accommodating for people who are trying to make requests based on creed, and that really the exemptions will be focused on medical requests. And even in those circumstances, it's going to be fairly limited. So I found that to be really interesting and quite an interesting signal. We'll move on now to Alberta. And so Alberta is fairly similar to Ontario. Under their Human Rights Act, they protect against physical disability, mental disability, and religious beliefs. Their Human Rights Commission has also put out a statement that said that personal opinion and political belief are not going to be protected. So again, very similar to what Ontario has said, that it's going to need more than just a belief that I shouldn't have to be vaccinated, or I don't trust in the science of the vaccine and therefore, don't want to be vaccinated. So they've said that more is required in that regard. They've also spent some time thinking about medical exemptions, and they have, in fact, an exemption program. And so they've kind of delineated all of the things that you would need to include on a medical note in order for it to be permissible to qualify as medical exemption. And so they've said that the letter has to outline the time period that the exemption is for, so that it's not something that is indefinite, but rather would have a temporal limitation. It has to be signed by a doctor or a nurse practitioner. It has to provide the person's name that would match their ID, the professional's name, and it has to state why you would have a belief that this person cannot receive the vaccine. So again, a little bit more prescriptive than what we would typically see, than for people asking for medical exemptions. So your note from your doctor that it's like Dr. Summeroff, right? Erin is off because of medical reasons. Erin can't get vaccinated for medical reasons. And so I think that the tribunal, or rather the commission in this case, as it is in Ontario, is suggesting that you can perhaps ask for more information. And then we move to BC. And so in BC, they also have protections in their Human Rights Code for disability and religion. The difference in BC is that it also offers this protection of political belief. So, as we just discussed in Alberta, where they said that there was no protection based on political belief, in BC, they've explicitly stated, or it's specifically part of their legislation, that there is protection based on political belief. And the British Columbia Human Rights Commissioner has said that the proof of vaccine requirement that, to go into restaurants or different shops and things like that is justified from a human rights perspective. And it's justifiable because there's this proportionality, right? That there is a need to protect individuals and those among us who would be considered to be the most vulnerable. Medical exemptions also are discussed, and there they say that it's vital in order to protect against potential discrimination on the basis of disability. However, demonstrating that someone is disabled isn't enough. There actually has to be a nexus between the disability and the reason why someone can't be vaccinated. And that would be similar in other provinces as well. The BC Centre for Disease Control has clarified that it's rare that a disability would prevent someone from actually receiving the vaccine. And they say that in most cases, it's actually preferable that someone would get vaccinated and that the pros of doing that would outweigh the cons. So again, we're seeing a lot of similarities. That's similar to what the Ministry of Health put out in Ontario, saying that it's only in these kind of exceptional circumstances where a medical exemption would be enforceable or would be valid. So that leaves us to a personal choice. And so while we can say that, yes, it is a personal choice whether or not someone wants to get vaccinated, that doesn't mean that that offers or affords protection under the code. So we'll go to the next slide, please, Andrea. The BC Human Rights Tribunal has come out with a process to follow when filing a complaint related to vaccine requirements. And although this was specific to BC, I do think that it's very similar across the country and certainly would hold true to Ontario. So the first thing is to look at what is the vaccine requirement. So is it a mandatory vaccine requirement? Is it a vaccination or test? Where does it restrict access to? And then you would look, how did the vaccine requirement negatively affect a person or group? And so here it has to, again, be based on a protected ground. So is the group disabled people? Is the group pregnant women? So you would look and see what the protected ground is. And then does it relate to a protected area? So employment or public services. How is a person in the complaint, so the respondent, how is a respondent responsible for the negative effect? And how is a protected characteristic a factor in the negative effect? So that is not uncommon to what process we would have gone through in any other human rights consideration. It's very similar. We've just replaced kind of the common, what we were used to dealing with the novel. So how do we apply that in a COVID world? So for the BC, when they're looking at political belief, and again, this is different than it would be certainly in Ontario, but the political belief could include having an opinion on matters of public discourse. So something like a government's policy or regulation to apply, for example, vaccine requirements or a vaccine passport mandate before entering certain service areas. And there is a decision out of the BC Human Rights Tribunal that has at least started to look at this. And they've said that they can accept that a genuinely held belief opposing government rules regarding vaccination could be a political belief within the meaning of the code. So having an anti-vax view or a view against government interference could be enough to at least meet the threshold that you have a political belief. However, it goes on, the tribunal goes on to say, however, protection from discrimination based on political belief does not exempt a person from following provincial health orders or rules. Rather, it protects a person from adverse impact on their employment based on their beliefs. So they're saying, okay, fine, the person still has to follow whatever the rules are, but they can't be adversely impacted, which I think is going to be could be very concerning for employers, because many of our policies would say that if you don't get vaccinated, that you are going to be put on an unpaid leave or you'll be terminated. So in theory, you could then be suffering from an adverse impact. So I think BC really, we have a lot to see about what's going to happen there because of this belief. And I think that's unique perhaps to the West Coast. The BC College of Physicians and Surgeons, we talked about this briefly already, about medical certificates. And so here they go so far as to say that the statements made must be truthful and based on objective clinical information about the patient and not simply a repetition of the patient's self-diagnosis, right? And so that, again, very typical of what we would see in an accommodation request. Patient tells me that she doesn't feel well. Patient tells me she has anxiety and can't go to work. So that's not going to be sufficient in this case. There's going to have to be more of a medical foundation. And certainly in Ontario, we've been telling some clients to attach the list that the Ministry of Health has put out and say, please confirm that your patient would meet one of the exemptions identified by the Ministry of Health. So we're not asking for a diagnosis, but at least we're asking for more than just a quick statement that would say patient is unable to get the vaccine. So then the Ministry of Health in BC has also talked about reasons for temporary deferral. Again, not permanent deferral, but a temporary deferral of the vaccine. I won't go through all of those, but it is similar to lists put out in other provinces as well. So again, a very kind of narrow definition of what would qualify. And then finally, looking at religion. And so across the jurisdictions, the definition of religion is quite broad, I think. So it has to be a sincerely held belief, as we've said. It also has to be something that someone feels like is part of their character, and it has to be part of an organized group. So you can't just have your own religion, but it actually has to be part of something bigger than that. Now, there are lists of some religious organizations that have stated that they're opposed to vaccine mandates. However, if you go to their websites of the founding organization, I find it very interesting. And I think in probably 95% of the cases that I've looked at so far, most of the religions will say that our religion allows for freedom of conscience. So people can make their own determination about whether or not to get the vaccine. So the religion itself doesn't say thou shalt not be vaccinated, but rather it says people have the right to choose. And so I've been denying those requests and indicating that in fact, it's not a religious belief, but rather a personal preference. So it's not that the religion tells them that they can't, it's decided that they don't want to. And often the reasons that people cite for not wanting to are because they don't trust in the science, right? And so it goes back to the very beginning when we were talking about Section 9 of the Quebec Charter, that's talking about the fact that it has to be rational and reasonable. It just can't be that you don't have trust in the government or you don't have trust in science. So that is that gives a general overview of the different human rights provisions. I didn't touch on the Canada Human Rights Code, and I will note only that the federal legislation, the Federal Human Rights Act, is similar in that it also protects against disability and religion there as well. And so now I will pass it over to Bonny, and Bonny will take all of this and talk about what does that look like in the context of mandatory vaccination policies.
Morning and good afternoon. My name is Bonny Mac. I am a lawyer in the Labor and Employment and Human Rights Group here in Toronto. Thank you very much for joining us this morning or this afternoon. So this presentation is the year in review in human rights law. This isn't really a seminar on vaccination policies, but given the times and given what Erin just talked about, which is the various protections under human rights legislation that may be applicable to vaccines, we thought that it might be appropriate to briefly talk about where the law is on mandatory vaccination policies. You've no doubt been seeing it in the news, dealing with it at work. So I apologize if you're already sick of the topic, but so I promise to keep this fairly brief, and there will be lots of time for questions at the end of the presentation. So when we're talking about vaccination policies, I always start with trying to clarify what we mean by mandatory vaccination. There are different types of vaccination policies out there. The first being what I call the true mandatory vaccination policy, as in vaccination is a term and condition of employment and continued employment of employees, i.e., you have to be vaccinated or you do not have a job. So I have included in the materials links to two news stories of two prominent employers who have adopted true mandatory vaccination policies, that being Air Canada and the Toronto Transit Commission. And the second type of vaccination policy that's sometimes referred to as a mandatory vaccination policy, but not really, is what I call the vax or test type of vaccination policies. Under this type of policies, employers encourage employees to be vaccinated. But if employees choose not to be vaccinated, it would not result in their employment being terminated. Rather, other health and safety measures would be put in place in order to ensure the safety of the workplace. And most frequently, the additional safety measures are regular COVID testing. With the wider availability of rapid antigen testing, a lot of employers are looking to rapid testing as an additional measure to help ensure workplace safety, where they have decided not to implement a true mandatory vaccination policy. So I have included here an example of that, which is the Ontario school system. They have adopted a vax or test policy, and staff members who are not fully vaccinated are required to take 2 COVID-19 tests per week. So now that we've clarified what kind of policies, there are further nuances within vaccination policies, because a lot of employers, especially larger employers, they may have different workforce who work in quite different workplace environments. So for example, some employers would have a mandatory vaccination policy with respect to employees who are working on site, in offices, etc. But mandatory vaccination requirement would not apply to employees who work from home. So there are nuances in how policies are being applied. There are also different treatment between existing employees and new hires. So we're seeing a lot of policies, both the true mandatory vaccination policies or the vax or test type of policies. We're seeing a lot of these policies requiring new hires to be fully vaccinated. So existing employees are subject to one regime, new hires are subject to a different requirement. So we're seeing that in basically industries where there isn't a recruitment issue. A lot of employers would like to adopt a mandatory vaccination policy for new hires too, but because of the labor shortage in some sectors of our economy, for practical reasons, they're not able to do that. So new hires are quite often treated differently. And then finally, regardless of what kind of policies an employer may have with respect to its own employees, we're seeing almost universally employers are saying to their contractors and to their vendors that we only want you to send fully vaccinated personnel to come to our premises to do work for us. So that's another prevailing practice that we're seeing a lot in our day-to-day work. So finally, everyone's been waiting with a bated breath for case law about mandatory vaccination policies. What does the law actually say? Like throughout COVID, we've been advising employers that, look, this is something that no one's ever dealt with before. The case law hasn't caught up to the times, and now we're seeing the case law starting to catch up. And now all three of these cases that are on the slide here are labor arbitration cases, i.e. they are cases decided in the provincial unionized sector. So these are arbitration decisions arising out of grievances filed by labor unions regarding their employer's vaccination policy. So I put the dates on the slides here to illustrate how recent these cases all were and how early we are in the development of case law on vaccination policies. So to underscore the point that I want you all to remember, if you only remember one thing out of my section of the presentation, is that we're very, very early on in the development of case law on vaccination policies. And these three are the first three decisions that have been issued. So so my advice, my suggestion would be not to look at these three cases as establishing a pattern yet. We are going to see dozens more cases issued in the future, and then and only then will we be able to draw conclusions about what the law says employers can and cannot do. So the first one out of the gate is a decision called Paragon Protection. So Paragon, as many of you may have heard of the employer, they employ security guards who work on customer premises. And a lot of those customers, virtually all of them, have either told the employer that they have adopted a mandatory vaccination policy with respect to vendors' employees, or that they are going to be adopting a mandatory vaccination policy. As a result, because their security guards work exclusively on customer premises, the employer, in this case, the security company, established that kind of a policy, a mandatory vaccination policy. So in that case, the arbitrator held that in that particular context of the workplace, a mandatory vaccination policy was justified and was reasonable. So the policy was upheld. And then later, 2 days later, we have another decision came out also about a true mandatory vaccination policy. And the second decision has to do with the Electrical Safety Authority as the employer. So in this case, arbitrator Stout engaged in an analysis based on what's called the KVP test. So the KVP test, as those of you who work in labor relations know, is the test applied frequently applied by labor arbitrators in determining whether a rule or a policy that is adopted by an employer unilaterally can be upheld or not in a unionized work environment. So the key factor, there are a number of factors in the KVP test. The key factor that arbitrator Stout looked at was whether the policy was reasonable, given the context of the workplace. And so in my view, arbitrator Stout's decision is an attempt to draw a balance between individuals' interest in having control over their body, having autonomy over their own medical treatment, versus the interests of an employer to maintain health and safety in the workplace, ensure that their employees, the customers, as well as members of the public with whom their employees come into contact with can be safe, as well as whether operationally a mandatory vaccination policy is justified based on operational requirements or not. And ultimately, in this decision, Arbitrator Stout did not find that the employer's policy was reasonable as it applies to employees who choose not to vaccinate and are then placed on unpaid leave of absence or have the potential to have their employment terminated. His reasoning is not that a true mandatory vaccination policy can never be justified. His reasoning was that in the particular circumstances of this workplace, it was the balance of interests resulted in a determination that a mandatory vaccination requirement is not needed in order to achieve the objectives of the employer. So the particular circumstances in this case included first, the employer had a very good track record in limiting the spread of COVID-19 in the workplace, and there have been no outbreaks throughout the pandemic in the workplace. Second, a lot of the employees that are covered by the policy have been working from home and can continue and will continue to work from home. And that's another factor that was taken into account. Third, there apparently was no operational issues arising from employees who are unvaccinated, and there have been no complaints from members of the public who come into contact with, for example, the inspectors employed by the Electrical Safety Authority. So in that context, Arbitrator Stout determined that the balancing of the interests resulted in his determination that the policy, the requirement that employees have to get vaccinated was not reasonable. But he did take pains to emphasize that it is very specific to the context of this workplace. And second, that things can change, circumstances can change. If we learned anything from this pandemic, is that the course of the pandemic can change and sometimes in unexpected ways. So Arbitrator Stout specifically said in his decision that should circumstances change, this issue of whether a mandatory vaccination requirement is reasonable can and should be revisited. And then finally, the last decision, the most recent decision that came out on November 12th is a decision by Arbitrator John Murray with respect to the employer Ontario Power Generation. And in this case, the arbitrator dealt with a vax or test policy as opposed to a true mandatory vaccination policy. And the grievance was in part about employees who are not vaccinated and who choose to refuse to undergo testing as required by the policy. In that case, Arbitrator Murray made some pretty strong and pretty definite statements about what these employees are doing by choosing not to follow the policy. To give you a couple of examples, Arbitrator Murray stated that what these employees are doing by choice is tantamount to making a decision to not show up for work fit for duty. And he went one step further to say that the employer in this case has provided an unpaid leave for employees to reconsider and to give employees to either become fully vaccinated or to decide to comply with the testing requirement. He then said that he then put these employees on notice in his decision that let there be no mistake. At the end of this unpaid leave, they will find their employment terminated, and that in his preliminary view, their termination would likely be upheld at arbitration. And then he went on further to say that employees who are not following the employer's vaccine test policy are making a decision to end their career with the company. So pretty strong statement there by arbitrator Murray. So with that, that concludes the vaccination discussion portion of this presentation. And next, my partner Rhonda is going to discuss language and pronouns and discrimination.
Thanks, Bonnie. So I'll jump right into this phase of the presentation on the use of pronouns. Andrea, if we could go to the next slide, please. Thank you. So we've seen in recent years, various jurisdictions in Canada have amended their human rights legislation, whether it's the Human Rights Code or the Human Rights Act, however we refer to it in the jurisdiction, to include explicit protections for gender identity, gender expression. We see that Ontario was maybe ahead of the game in 2012 in including gender identity and expression as prohibited grounds of discrimination. Other jurisdictions have followed suit, namely we've got Quebec in 2016 that amended the Quebec Charter to take this into account. We saw amendments also in the federal jurisdiction under the Canadian Human Rights Act to also include gender identity and expression as a prohibited ground of discrimination. What's new and interesting is that in the last year or two, we've seen courts and tribunals and commissions start to issue practice guidelines and directives inviting lawyers and witnesses to provide guidance to the whatever the body is that we're in front of as to how to identify or how to refer to them and how to use the correct pronouns and their preferred form of address. Next slide, please, Andrea. Another thing that we've started to see in the last couple of years, I think what's become quite common is that myself and some other of my Fasken colleagues, and we're seeing this more and more with clients across industries, are using their preferred pronouns in their email signature block. And this is part of a shift, a cultural shift, where we're recognizing more and more that commonly used pronouns, he, him, she, her, may not fit with how a person chooses to self-identify. And so the use of personal gender pronouns, for example, in the signature blocks, are a way of normalizing conversation around gender identity. It indicates to the recipient that we are welcoming and will be respectful of their identity. It also removes confusion, so we don't have to guess as to how a person, what a person's preferred pronouns are. And in general, the practices seem to contribute to creating a safe workplace and an inclusive environment. So now I'll take you to a couple of actually very recent decisions that have come out of BC and Ontario in the last few weeks. The first one is Nelson and Goodberry Restaurant. This is a decision that's been very widely discussed in the media. You might have seen a Fasken bulletin on it. It seems to be the first decision in Canada where an employer is ordered to pay damages for an employee willfully ignoring another employee's gender identity and preferred pronouns, which overall contributed to gender identity discrimination. Next slide, please, Andrea. So in this case, the applicant was a non-binary, gender fluid, transgender person who used they, them as pronouns. When they were hired, they explained to the general manager the importance that they were, being properly gendered amongst their colleagues in the workplace. And despite that, the bar manager in this case continually referred to the applicants at work using she, her pronouns and using gendered nicknames such as honey, sweetie, sweetheart. The applicant repeatedly asked the bar manager to stop and to either refer to them using their actual name or their preferred pronouns. Eventually, the work climate deteriorated. The applicant tried to bring it to the attention of the employer. The employer did take certain steps, but perhaps they weren't fast enough or diligent enough in addressing the issue to the point where the applicant felt that it was difficult to work with the bar manager. The bar manager was affecting their work performance. For example, their drinks were coming out wrong, or the bar manager was taking his time in fixing drink orders, which was delaying them in serving customers. Ultimately, the applicant felt that the restaurant, the employer, was not acting fast enough to address the issue. The applicant decided to confront the bar manager themselves after work one day, and they ended up getting into a very heated discussion in front of restaurant staff. And then the next thing that happened a couple of days later was that the restaurant decided to terminate the applicant's employment after this heated discussion with the bar manager. So during the call that the employer made to terminate the applicant, at first the owner of the restaurant avoided giving specific reasons. They were being vague on why they were terminating the applicant, just saying that they were being terminated without cause during the probationary period. But the applicant pushed forward to get more answers. And eventually the employer told them that they had come off as too strong and too fast in the workplace. They were too militant. And part of the problem that led to termination was making sure that they vibed with the rest of the team. And the owner also said that they had made people in the workplace uncomfortable. Next slide, please, Andrea. So the findings here made by the tribunal were that the applicant suffered discrimination on the basis of gender identity or expression in the workplace, and the employer and the bar manager were the respondents who were responsible for the discrimination. Here, the tribunal found that the employer is well aware of the bar manager's use of misgendered pronouns and gendered nicknames towards the applicant. The Human Rights Tribunal also found that the employer's response to address the complaints by the applicant fell short of what was reasonable and appropriate in the circumstances, and actually sowed the seeds for the altercation that eventually led to the applicant's termination. And the tribunal was really explicit in recognizing that employers have obligations under the Human Rights Code to respond reasonably and appropriately to complaints of discrimination. This includes a duty to investigate where there is a complaint of discrimination. And the tribunal found that a failure to properly investigate in a reasonable or appropriate manner can itself contribute or be the basis of discrimination under the code. Excuse me. Some factors, the tribunal said that some factors that may be considered are whether the person charged with conducting the investigation of discrimination has a proper understanding of what discrimination means and what can or cannot amount to discrimination. And another factor that will be evaluated is whether the employer treated the allegations seriously and acted with sensitivity in receiving and listening to the complaints and in addressing them. And also whether the complaint is ultimately resolved internally or not in a manner that contributes to or ensures a healthy work environment for the person that's making the complaints. With regard to the termination, it was recognized that the applicant has to show, the burden is to show that their gender identity or expression was a factor in the decision to terminate. The tribunal stated very clearly that it doesn't need to be the only factor or even the overriding factor that led to termination, but simply one of the factors that led to the termination. And on this point, the tribunal said that it had absolutely no difficulty concluding that the applicant's gender identity was a factor, if not the factor, in the termination. It was very apparent to the tribunal that the applicant was terminated in connection with their efforts in the workplace to address discriminatory treatment. Next slide, please. So the award ultimately was $30,000 as compensation for injury to dignity, feelings, and self-respect. Some factors that were taken into account were the applicant's particular social context or vulnerability in society, and the personal effect that the discrimination had had on the applicants. What was interesting is that the remedies ordered included an order that the employer amend their employee policy to explicitly affirm and recognize that every employee has a right to be addressed with their own personal pronouns. The tribunal also ordered mandatory training for all staff and managers on human rights in the workplace. And if we could skip to the next slide, please, Andrea. So the second decision. Oh, sorry, you can skip ahead again. Yes, thanks very much. So the Ian and Gallagher decision, this one also came out in the last few weeks out of Ontario. I'll go through this one a bit more quickly because the damages awarded did not directly turn on the misuse of pronouns, although this decision we think is ripe to inform future decisions that are going to evaluate gender identity, gender expression, and sex in the workplace. Here, the applicants, it was a group of applicants actually, identified as either genderqueer or non-binary and used they, them pronouns. The group of employees in question were kitchen staff at a restaurant that was managed by the owner. And the applicants alleged that the owner refused to use their correct or preferred pronouns as they had requested repeatedly. The owner misgendered them and likened their requests that they be referred to properly as causing him to walk on eggshells. The applicants also alleged that they had overheard the owner talking to customers and using transphobic slurs to refer to the employees. When the applicants raised the concern to the owner, he denied using a slur to customers, and he refused to address the applicants' concerns any further. Ultimately, the group of applicants quit their employment. They felt that their dignity, their safety, and their privacy were simply not being taken seriously. Next slide, please. So in the decision, the tribunal held that the transphobic slur was made in a public setting to strangers of the employees in question, who were customers, which effectively had the effect of outing the applicants to the customers in a very public way, and even making them fear for their safety. The owner, they found, also failed to adequately respond to the applicant's concerns and to investigate. The applicant's loss of employment was seen to be a byproduct of feeling that they were simply left with no choice but to leave a workplace in which they didn't feel safe and didn't respond to their concerns. What the tribunal did state here was that the misgendering or the use of incorrect pronouns was an adverse treatment suffered by the applicants in their employment. Next slide, please, Andrea. So the remedy is awarded $10,000 to each applicant for injury to dignity, and an amount to each of them for lost wages. If I go back to the misgendering and the use of pronouns, the tribunal here did not specifically award damages on the basis of the misuse or the deliberate misuse of pronouns, simply because it found that the applicant's evidence in their pleadings was deficient on that point. So it didn't go into enough detail, or it wasn't robust enough. But the tribunal did make it very clear that the act itself of intentionally misgendering a person in the workplace and the deliberate misuse of pronouns can constitute adverse treatment in the workplace, even if this isn't specifically in and of itself a ground of discrimination recognized in human rights legislation. It's part of gender expression, gender identity. And so with that recognition, this decision paves the way for future damages to be awarded in future cases on incorrect pronoun usage constituting adverse treatment under the code. And now I will turn it back over. Yeah, these are some factors that were important in the amount of damages that I want to skip ahead to, and that the participants can go through later on with the PowerPoint. I'll let Erin take it from here. Thanks.
Thanks, Rhonda. Next, we're going to talk about systemic discrimination. And this is top of mind this year, in the past year, of course, because the Supreme Court of Canada released a decision just towards the end of last year, Fraser v. Canada. And so this was a case that was brought by, I believe it's 4 different women against the RCMP. And these women were job sharing, and they were in job sharing arrangements after returning from being on parental leave. And so they came back into this job share, and as part of the job share, they were not permitted to continue to contribute towards their pension. And so despite repeatedly asking whether or not they can contribute to the pension or buy back their pension when they returned to full-time work, they were told that they couldn't. So, this is a classic example where on the face, this is a neutral policy that no part-time employees can buy back pension or can contribute to pension. The complainants were alleging that it had an adverse impact on them because they were women. And when you actually looked at the statistics of who had taken or who went into these job sharing arrangements, they found that at the time of the application, or the application was filed with the court, that every single person who had been in a job sharing arrangement was a woman with childcare responsibilities. And so they said because of that, it was clear that this neutral rule had an adverse impact on women, and that women, particularly mothers in the workplace, were already at a disadvantage and a disadvantaged group. So the Supreme Court overturned the earlier ruling saying that there was no discrimination and found that, in fact, this neutral policy did engage in discriminatory treatment, and that it was an example of systemic discrimination. And so when you take that and you look at the context of how have courts and tribunals been applying that decision over the last year, there are 2 interesting cases that have come out of BC. And so the first one has been brought by a woman, and I'm going to try and say her name, but Kirchmeier. So I apologize if I'm butchering that throughout. But anyway, she brought a complaint against the University of British Columbia on behalf of others. So on behalf of herself and behalf of others. And this decision relates to an application that the university brought to have the matter dismissed. And they sought to have it dismissed for 2 reasons. First, that there was no reasonable prospect of success because they said that the applicant herself had not been the victim of discrimination. And then second, they also sought to have it dismissed because there had already been a remedy. And so there would be no purpose in going through with the hearing because the university says it has amended all of its policies and procedures pertaining to sexual harassment. And so that nothing further really should be done. But the complaint, if we look at just the factual basis of the complaint, and the tribunal spent a lot of time actually looking at what the facts of the complaint were, the background to the complaint. Here, it's about a student, a PhD student, who was alleged to have engaged in various sort of sexual harassment and discriminatory behaviors. And it ranged from, pulling a woman's ponytail, very kindergarten playground kind of behavior, all the way to allegations of rape. So, there was quite a broad range of complaints, and the complaints had been filed over a period of time. Ultimately, this does go to review, and the committee decides to expel the student in 2015. But this is after, as I said, a long period of complaints. So if we go to the next slide, we can see that the complainant, when she brought this application, brought it on behalf of herself in two classes of women. So the first were those who had raised concerns specifically about this student, and then the second were those that had raised concerns about other men. And the claim was that the policy that looked into sexual harassment complaints and the procedure that was followed had an adverse impact on women. So again, although it may be a neutral policy in and of itself, it had an impact on women. And after this review, the university hired an external investigator, and the investigator went and looked at how this complaint had been handled and determined that there were some areas of improvement. So, for example, the complaint had taken too long to investigate. There was a suggestion that they weren't looking into matters because they claimed it was outside of their jurisdiction, because some of the behaviors had occurred while the student was offsite at conferences, although he was there representing UBC. And then also one of the individuals made a comment saying, suggesting to women that they shouldn't talk about their complaints too much, because to do so would be like throwing a snake into a dark room. So suggesting that, it would create fear amongst the women if they were to talk openly about it. And so it's this kind of behavior that led the complainant to bring this application. And if we go to the next slide, the tribunal determined, and again, remember, this is just about whether or not the complaint should be dismissed at first instance for not having a reasonable prospect of success. And so the tribunal said that the complainant doesn't actually have to prove that UBC's actions were motivated or casually connected to sex. It's sufficient to prove that women were adversely impacted in connection with UBC's services and that sex was a factor. And similar to the Supreme Court case in Fraser, where we talked about the fact that all of the women at the time that the application was filed, or all of those in job sharing arrangements were women. So it's similar here that the majority of people who file complaints about harassment and sexual harassment are women. And so the tribunal said, in this case, it would be open to the tribunal to conclude that the connection between sex and sexual misconduct is of a similar, commonly understood nature, such that the requisite nexus can be inferred from the disproportionate representation of women among the people impacted, both directly and indirectly. So they said that it was enough that it's likely that this entire group of people were women, and that when you are looking for evidence, you would look at those kind of statistical markers, and that would be part of the indication to determine whether or not, in fact, there had been adverse discrimination or not. And so this case will go on. It'll be interesting to see what the tribunal actually does with the decision on the merits, particularly against these two classes of women, because it's been fairly standard that you would, in order to be successful and in order to bring forward a human rights complaint, you have to be complaining on your own behalf, and that you can't just complain about discrimination at large. So this may alter or shift that approach. The second case that I want to quickly touch on is Lord versus Fraser Health Authority. And so again, this is a case looking at the gatekeeping role of the tribunal. And in this case, Miss Lord was terminated from her employment for cause. She engaged in a number of things, allegedly, such as calling her supervisor names, making threats against him about his personal safety. There's allegations that she was drinking on the job and giving alcohol to clients and alcohol-dependent clients. So there's quite a long list of fairly serious allegations that were made against her. And if we go to the next slide, we can see that the employer was asking about the complainant's state of health. So they were asking about her mental health and asking if there was any way she needed to be accommodated. And so she kept saying, I don't need to be accommodated. I'm accommodated just fine in this job. This job is just fine for me. And it comes out at the tribunal that she does, in fact, have bipolar disorder. But she never brought that forward to the employer. And so the employer ultimately then dismisses her and says, okay, well, you didn't bring forward the fact that you have a disability and you didn't ask for accommodation. Therefore, we take the behaviors or the alleged actions that you were involved in, and we determine that that's worthy of dismissal for cause. And initially, if we go to the next slide, you can see that the BC Human Rights Tribunal dismissed the case and said, yeah, that's right. That's right. That if you're not going to bring forward and be forthcoming about the fact that you have a disability, then you're not protected under the Human Rights Code or in BC, the Human Rights Act. And so therefore, her complaint was dismissed as having no reasonable prospect of success. Now, she appealed that decision, and on judicial review, the court overturned the tribunal's findings. And if we go to the next slide, you can see that they said that gatekeepers, such as the tribunal, have to be sensitive to the fact that there could be an adverse effect of discrimination on those in this realm. So those who have disabilities and who are nervous or unable to come forward about what those disabilities are could be adversely impacted by the neutral rule that they have to be forthcoming. And so here again, it's the legal nuance required to demonstrate a nexus or connection between a protected ground of discrimination and the adverse impact a complaint experienced can be complex and difficult to demonstrate. However, it's up to the tribunal as a gatekeeper to be sensitive to that and to make sure that they are paying attention to those requirements. And so in this case, it was determined that the BC Human Rights Tribunal failed to take into consideration the evidence of the complainant, and rather they only sort of relied on the evidence of the employer. And typically the tribunal, when looking at an application to dismiss, is supposed to look at an application and say, assuming everything that the applicant put in the application is true, would I dismiss this? And so the court said that they failed to meet that obligation and therefore sent the matter back. And so I think there's one more slide. And so again, the adverse impact discrimination may play a role in the ability or willingness of a party to disclose. And so, as we said, the requirement to disclose is fairly common in human rights accommodation cases, and it's a neutral rule, but it has an impact on those, particularly those with mental health disabilities. All right, and so Bonny, we will pass it over to you to talk about family status.
So we've been doing these year in review seminars for a few years now, and every year there's a placeholder on the latest chapter in the saga that is family status, discrimination, and accommodation. I started practicing law in 2007, and that was when family status discrimination was a quote-unquote new thing, even though the ground has been in human rights legislation forever and ever. So what is family status? As most of you know, family status is defined as the status of being in a parent-child relationship. So quite literally, all of us are in a parent-child relationship. We're either a parent or at the very least, we're children. So the struggles that decisions makers have and academics and lawyers have is to articulate a test for family status discrimination, which which makes it more limited so that there isn't a need to accommodate everyone who's got childcare needs, for example, that there isn't a need to accommodate everyone who's got elder care responsibility. The idea being it would be too overwhelming. It means that virtually every person would have the potential, would have basis on which to ask for accommodation. And that is thought of as being too unwieldy and too unmanageable. That, in other words, that can possibly be right. So the development of the case law somewhat illustrates this kind of attitude about family status discrimination. So the earliest cases at the Court of Appeal level are the Campbell River and North Island Transitional Society case that came out of BC, came out of a community-based social service provider, and it went to the BC Court of Appeal, and the BC Court of Appeal articulated a test which requires a change in the terms and conditions of employment, which then has a substantial impact on the employee's childcare responsibility. So that test outlined by the BC Court of Appeal is still good law in BC, but it's been under attack by adjudicators in other jurisdictions. So in 2014, we've got the Federal Court of Appeal with the Johnstone decision. So the Johnstone decision does not follow Campbell River. Instead, it outlines, it tries in its own way to circumscribe the scope of family status discrimination. It introduced this notion that employees are required to self-accommodate. So that quickly became the new buzzword, self-accommodation. Has the employee self-accommodated? If the employee hasn't self-accommodated, then we don't have to do anything. Not so, says the Human Rights Tribunal of Ontario. So the leading case in Ontario is actually a HRTO decision involving Value Village stores. In that case, the vice chair of the HRTO, Jennifer Scott, she rejected both the Campbell River and the Johnstone tests. She stated that there's no principled reason to outline a different test for whether there is discrimination for family status as compared to the other grounds. And she's right. Under any other ground of under any other prohibited ground of discrimination, there isn't the extra requirement that there was a change in terms and conditions of employment. There isn't the extra requirement of self-accommodation before discrimination can be found. And then most recently, earlier this year, we have the Alberta Court of Appeals decision in Alberta Health Services. So there is a review of the Alberta Health Services decision, as well as the development of the case law in my colleague Andrew Woodhouse's HR Space article. I have provided a link to all of the court decisions, as well as a link to Andrew's article in the presentation materials there. So what does the Alberta Health Services case say? The Alberta Health Services decision, the Court of Appeal says that, well, it doesn't make sense to have a different test for family status discrimination. So along the same lines as what the HRTO decision in Value Village stores said. So the Alberta Court of Appeal followed this test for prima facie discrimination that is outlined in a case called Moore, a Supreme Court of Canada decision. So the duty to accommodate arises whenever there is prima facie discrimination. Prima facie discrimination is the fancy lawyer way of saying on its face there is discrimination, and which triggers the duty to accommodate up to the point of undue hardship. So there are three components to this test for discrimination. First, the employee possesses a protected characteristic. in the context of family status discrimination, it means that the employee is in a parent-child relationship. And most frequently, the issue that engages family status discrimination and accommodation is either childcare responsibilities or elder care responsibilities, a need to take care of one's parents or grandparents, and where those responsibilities conflict with a work-related requirement. Second part is that the employee experiences an adverse impact with respect to their employment. Now, those, like I was saying, these issues arise when family care responsibilities, child care responsibilities, elder care responsibilities conflict with a work-related requirement, such that the employer is saying, well, this is what you're required to do as a part of your job. You're not doing it. What's going to happen? And then thirdly, the protected characteristic is a factor in the adverse impact. So as with any sort of discrimination analysis, the protected ground or the prohibited ground of discrimination does not need to be the sole reason for the bad thing happening to the employee. So for the adverse impact, it only has to be a factor in the adverse impact. So in the context of family status discrimination, we could see a scenario in which an employee is unable to work a particular shift pattern because he or she doesn't have appropriate childcare, which would allow the employee to work that shift pattern. As a result, the employee then is either then terminated because he or she said that she couldn't work that shift, and the employer refuses to make any changes. That's one potential adverse impact. Another potential adverse impact is the employee decides that, well, I have no choice. I can't not take care of my kid. So I have no choice but to step down to either a part-time position or step down to a casual position, impacting their income and benefit coverage, for instance. So that's another type of adverse impact. So because we're in the midst of a pandemic, we're getting some questions from clients about, well, as we seek to bring employees back to the office, back into the workplace, what sort of issues may come up as it relates to family status discrimination and accommodation? And what is the practical way forward, given that we are still not in the last chapter of the saga? That's the differing legal tests for what constitutes family status discrimination. So our advice typically is, unless you want to be a test case going forward, unless you want to test what the limits of the law is, unless you want to try to make new law, the practical advice, the practical approach is to engage in the accommodation process. If we could go to the next slide, please, Andrea. What do I mean by engage in the accommodation in the accommodation process? In a lot of cases, and in talking to employers from time to time, they ask me, "Do I have to accommodate? This is the situation. Do I have to accommodate?" And they could outline a situation in which the employee is unable to secure childcare close to their home, or their childcare provider has now reduced hours as a result of COVID or for whatever reason. And the question that was asked to the lawyer, me, on the other end of the phone line was, well, do I have to accommodate? Do I have to give them the shift that they want? Well, to me, that's not exactly the correct question to ask, because of the uncertainty in the law about whether employees are required to self-accommodate, about whether there is this additional requirement of a change in the terms and conditions of employment. It is safer, more practical for us to assume that whenever something like that comes up, that our duty to accommodate is engaged, and that we have to start the accommodation process. It doesn't necessarily mean you have to give the employee exactly what they're asking for in terms of accommodation, but the answer cannot be, well, I don't think I need to accommodate in this situation, and so please go away. And that is an approach that is likely to get us into trouble. So how do we determine whether a situation exists? Well, we should go back to the test under Moore, whether there is. So the first step is determine whether there is a protected characteristic. In this case, is this person either a parent or a child? The second, is there a conflict between their family care responsibility with work requirement? Quite often the answer is yes. And third, whether there would be adverse consequences if accommodation is not provided. So that is a very easy test to meet when it comes to things like childcare and elder care responsibility. So that's why I think that instead of asking the question of do we have to accommodate, always skip over the question and go straight to, okay, let's engage in the accommodation process. What does the accommodation process involve? Well, as HR professionals, as employers, many of you are familiar with it. The first step is to obtain relevant information about the need for accommodation and the way in which the work-related requirement conflicts with that person's family and family or elder care responsibility. And second is to come up with an accommodation solution. And this is the part where we can ask questions about what the employee has done in order to, for example, obtain childcare. What arrangements have they made for elder care, etc. It's not exactly asking a question about self-accommodation, because lots of times when people say, well, the person's supposed to self-accommodate, it was used to answer the question of whether we have to accommodate this person. So in the Value Village Store's decision, the vice chair commented on the fact that even though self-accommodation should not be a requirement to prove prima facie discrimination, employers can inquire about efforts the employees has made in order to care for to fulfill their family care responsibilities, because accommodation is a multi-party inquiry. Employees have responsibilities in their own accommodation as well. Other things to bear in mind as we try to navigate a return to office and potential family status discrimination issue is that just because an employee was able to manage his or her child care responsibilities or elder care responsibilities before the pandemic started, don't assume that status quo remain, because a lot has changed in the last 20 months. Daycare providers have shut down, hours of operations have changed, and some families have actually moved their elderly parent or grandparent from retirement residence back home out of concern that the communal living settings may not be safe for their parents or grandparents. So don't assume that just because people didn't have family care needs pre-pandemic, that the status quo will remain. It's really important to take a consistent approach. If we're going to get a large number of these requests for family status discrimination, it's important that we follow the same approach or follow the same process in assessing these requests. Practically, it means we need to be proactive and provide guidelines for managers. We can't just let managers use their best judgment, because that is truly a recipe for inconsistent approaches. And secondly, is to provide HR support to our frontline managers, help managers identify and issue spot, identify situations in which further inquiries should be made, and that HR support should be sought in responding to family status accommodation requests. And a couple other things that are going to seem very basic to all of you is, if we're going to have employees come back to the office, give advance notice. Give people time to make arrangements, because most of the time, if given enough time, people can figure it out. And also built in a transition period. Don't expect that after 20 months of people working from home, almost full-time or full-time, that they can all of a sudden come back to the office 5 days a week. Allow for a transition period. And then the other thing that we need to keep in mind is that it's not strictly speaking a human rights issue, but that in provincial, in employment standards legislation, including the Ontario Employment Standards Act, there are unpaid leaves that are available to employees in order to fulfill their family care responsibility. So I'm looking at the Ontario Employment Standards Act, the unpaid infectious disease emergency leave. I printed it out, and there is 2 full pages of circumstances in which employees are entitled to the leave. And this one is particularly relevant, is where the employees is providing care or support to the any of these individuals because of a matter related to a designated infectious disease. So the list of individuals are essentially an employee's immediate family: spouse, parent, step-parent, child, stepchild, brother, stepbrother, sister, stepsister, grandparent, step-grandparent. You get the idea. The ministry has also very helpfully outlined what, in their view, would qualify an employee to take this leave. And I'll just quickly go through a few of these things that the Ministry of Labour in Ontario says would qualify an employee for an unpaid infectious disease leave. Example, an employee taking leave to care for their child whose school or childcare was closed because of a designated infectious disease. That sounds reasonable. And then it goes on to say, or because the employee did not send their child to school or childcare out of fear the child would be exposed to COVID-19. That's the ministry's position. And then also includes situations where the employee's child had a symptom that did not automatically require the child to stay away from school or childcare. So little kid has the sniffles, but the employee was concerned that the symptom may relate to COVID-19 and chose to keep the child home as a precautionary measure. So just bear in mind that when you hear things like, well, I decided to keep my kid at home because I'm afraid that he or she will catch COVID, because there were a couple other kids in her class who seemed to have flu-like symptoms. Well, don't be too quick to dismiss employees' request for leave, because according to the Ministry of Labour, those are valid reasons to take leave. So with that, we're going to move on to our next topic, which is the ever-increasing human rights damages.
Thanks, Bonny. Another topic that we always make sure to touch on in these webinars that we give. There's 3, thanks, Andrea. There's 3 cases that I wanted to at least touch on briefly in the time we have left before the question period. If you could pass to the next slide, please. The first decision of Francis is particularly important. It's the highest injury to dignity award issued yet by the BC Human Rights Tribunal. Here, the tribunal awarded $176,000 for injury to the victim's dignity, which was part of an overall award that totaled almost $1 million. And before this decision came through, the highest injury to dignity award out of BC was $75,000. So this award surpassed, it outskirted past awards by more than half. Just to go through the facts quickly, the complainant here, who identified as Black, worked as a correctional officer, and the tribunal found that what he suffered on a daily basis ran virtually the entire spectrum of racial discrimination and harassment in the workplace, including racial slurs, stereotyping. He was denigrated in front of other officers. When he took issue with the treatment, including the use of the N-word in the workplace, he was called sensitive. Ultimately, he filed a human rights complaint, and then, to make matters worse, suffered retaliation on at least 2 occasions in the workplace by his supervisors. He was called a rat. He was told that there was a target on his back. The tribunal concluded that the behavior that he suffered, the conduct he suffered in the workplace, was extreme. And there were a few factors here that I think overall contributed to this enormous award that he received. One of the factors was the emotional impact that the treatment had on him. So on what turned out to be his last day of work, on which the death of an inmate occurred, the complainant here had an emotional breakdown and left work and didn't come back. And this was found to be part of, an accumulation of emotional distress that over time, over several months and years, built up. Next slide, please. The next slide, please. So if we look at the remedies that were ordered, like I said, it was he received an overall award of almost $1 million. The Injury to Dignity award was a big part of that. And the factors that were looked at by the tribunal were the severe nature of the discrimination, the long period and frequency of the discrimination, which in some cases was on a near daily basis. The vulnerability of this particular complainant because of the nature of the workplace that he was in, the impact on his mental health. Next slide, please, Andrea. The tribunal found that what he experienced ran virtually the entire spectrum of racial discrimination and escalated to the point of him suffering retaliatory behavior in the workplace and contributed to an overall poisoned work environment that really required an extremely significant award as compensation. And if we turn to the next slide, we'll see some of the factors in the next two slides, the factors that the tribunal looked at in particular. What they found was that the conduct was an exceptionally damaging affront to Francis's dignity. The comments and the actions of his coworkers struck the very core of his identity and feelings of self-worth and his emotional well-being. Because of the nature of his workplace, which is a correctional facility, it was found that he was particularly vulnerable because of the nature of his job. So his physical safety in this case was threatened and potentially compromised because of the discriminatory and retaliatory behavior that he suffered by other officers and by supervisors on whom he needed to be able to count on in order to feel safe in his workplace. So he ended up developing a genuine fear that if something dangerous were to happen at work, that he could not count on his colleagues for help. And the tribunal reiterated that the principle, the purpose of an Injury to Dignity award is to compensate the complainant for the actual harm suffered as a result of the discrimination. And here the effects were extreme. The complainant remained, even to the date of the trial and the awards that happened several years after he had left work. He remained seriously ill from a psychiatric point of view. He had lost his ability to work. His wife testified that the experience had destroyed him as a human. So the amount that was awarded as Injury to Dignity was seen to be reasonably proportionate by the tribunal. The tribunal also saw fit to remind us that there is no actual cap on an amount of damages that could be awarded for injury to dignity under the legislation. And tribunal thought that this was an appropriate award due to the severity of what he had suffered. The next decision I will go through rather quickly because it doesn't involve, if you could just skip ahead, Andrea, thank you. This decision was not in the workplace, but it shows an increasing trend of damages awarded in racial profiling cases. This one came out of Quebec. Here, the city of Gatineau in raising arguments tried to convince the tribunal that there had not been racial profiling because the suspect that the police were looking for in this particular instance was described as Black, and the complainant, who was the victim of police behavior, was also Black. So the tribunal found that this argument was a very simplistic argument that annihilated all the work that we've been doing in past years to try and address racial profiling and recognize it for what it is. Ultimately, the tribunal found that the question that we need to address when we're looking at racial profiling is whether the person who is in a position of authority would have acted differently if the complainant had not been a member of a group protected by protected grounds under the charter. So meaning in this case, if the victim had not had Black skin, and the tribunal found that the police officers would have treated the individual differently had it not been for the color of his skin. That was enough to constitute racial profiling. The damages that were awarded, if you could skip to the next slide, please. And ahead again. $15,000 for moral damages and $3,000 as punitive damages. The awards in Quebec tend to be, from what I can tell, quite a bit more conservative than in other provinces out of the Human Rights Tribunal. So this award of $15,000 moral damages is actually the highest moral damages award in when we looked at racial profiling decisions out of Quebec in recent years. I'll just move ahead to the last decision, the Kavaska decision. Thank you. So this is a decision out of the Human Rights Tribunal in Alberta. The complainant here worked as a commission car salesperson, and he had advised the employer when he started employment that he did not have a driver's license due to alcohol-related driving offenses. So already we have an inkling that, or should be alive to, a potential issue. The complainant, over the course of the first few months of employment, began drinking very heavily, started coming to work drunk every day. He began a process of applying for disability benefits in order to enter a rehabilitation program. But before the application was completed, the culminating incident occurred that led to his termination of employment happened. So he showed up at work heavily intoxicated. He interrupted a staff meeting and was belligerent toward the general manager. After that incident, he was called by his employer and told not to come into work. He ended up presenting himself to work nonetheless, and that's where he was advised that he was being terminated. At that point, the complainant advised the employer that he had an alcohol addiction, and he actually asked for a chance to enter a rehabilitation treatment program. The manager told him that too many people knew about what had happened, about the incident he had caused, and it was effectively too late to give him a last chance in order to enter a rehabilitation program. Next slide, please. So in evaluating this decision, the facts here, the tribunal found that the complainant obviously had a disability, which was an alcohol addiction, and that his disability was a factor in his termination. Moreover, the employer knew that he had this disability, or ought reasonably to have known that the complainant suffered from this disability. And because of that, the employer had a duty to inquire whether the complainant's performance, and particularly this act of belligerence during a team meeting, was tied to or was somehow affected by his disability, and moreover, whether accommodations were possible in the circumstances before actually terminating his employment. Next slide, please. What the tribunal here says is that there's no limit in the statute, as we've seen in the previous decision. There's no limit in the statute as to the range of damages that can be awarded, and that past benchmarks should not serve to create any sort of arbitrary cap on damages awarded in future decisions. And this is actually a principle that the Alberta Court of Appeal had looked at and had rejected, the fact that we can't be held to arbitrary caps based on past benchmarks in past decisions. Next slide, please. The damages awarded here are $30,000 for injury to dignity. And what the tribunal emphasized here was the particular impact that the discrimination had on the complainant, which included humiliation, loss of self-respect, dignity, ultimately the loss of his job and benefits, which actually occurred at his time of when he was in his greatest need, and ended up having a psychologically devastating impact on him, to the point where he wasn't able to return to the industry later on. So the employer's behavior here, and in particular, the denial of a last chance when specifically requested in order to enter a rehab program, was particularly was taken into account in a very particular way by the tribunal in considering the damages that were appropriate. That completes the presentation. I'll turn it over to Erin now for the question period.
Thanks, Rhonda. Hi, everyone. I know that we have run a few minutes over, so we understand if people do need to drop off, but we will stay for a few minutes just to ask a couple of the questions that have come in. So the first question, and Bonny, Rhonda, I don't know if either of you want to jump in, but we had a question about when hiring an individual, and if you're requiring that an employee be vaccinated in order to be made an offer of employment, at what process during the hiring, or at what point during the hiring process can you actually ask for confirmation of their vaccination status?
I'm happy to take that one. So there are two parts to the answer to this. Is first, it is permissible to outline in your job posting or your job application form that your company requires as a condition of hire that individuals be fully vaccinated. So there's nothing wrong with having that on your job posting or your job application form, provided that you also comply with the AODA's requirement to state that the employer would provide any job candidates with reasonable accommodation, both during the recruitment and selection process and during employment. And so first of all, that statement should put people on notice that this would be a requirement and maybe help screen out folks who are not vaccinated by their self-selection. And the second, going back to the question of the timing of asking for vaccination status, our recommendation is the same as what we recommend for things like background checks. It should be asked when you're at the point of making a conditional offer of employment and not before. And the reason being, before we even know that this person is qualified for the job, we don't want to be asking for information such as vaccination status. We don't want to be, just like we don't want to be running background checks on those folks. So the timing that we recommend is when we're at the point of making a conditional offer of employment, i.e. your offer of employment would be conditional upon successfully passing the background check and providing proof of full vaccination.
Thanks. We've also had another question, and actually several questions who are asking about how do you know that someone has a sincerely held religious belief, and what type of information can you ask for from your employee in order to substantiate that? And, you know what, truthfully, how to tell that someone has a sincerely held belief, I think, is the $1 million question. And it's not an easy determination, but I think that you can ask for certainly a written statement or attestation, and so that somebody can outline why it is that they're requesting accommodation based on religion or creed. And then you can also ask for a statement from a religious leader. And then often when you look at those, you can determine just from what's being said within them, whether or not this is actually, again, based in religion, or if it's based on a distrust in the science. So, for example, as I said, many of the religious requests that for exemptions that I'm seeing state that their religion allows them to have freedom of choice or freedom of conscience. And then when they go through and they're writing out the reasons for this, they're stating that they don't want to get the vaccine because they don't believe that it's been properly tested, or they think that it's too early to tell whether the science will support it, that we're not really in a pandemic or a health crisis. So those are things where you say, okay, well, your concern isn't actually then based in religion. It's based on a personal belief that is a distrust in science. So, there is no easy answer, but I think that you can ask for documents that would confirm somebody's request for accommodation. And then the other question that we've had is about the ability for people to claim damages both for mental health, both under a WCB, so a Workplace Compensation Board, and human rights. And do we find ourselves ever in a position where somebody may be claiming damages under both, through both administrative bodies? And so Bonny and Rhonda, I don't know if you guys have any thoughts on that one at all.
I don't know practically if that would happen. I've never seen complaints be treated in two different forms, at least in Quebec. What we typically do is suspend a complaint from proceeding when it's based on the same or very similar allegations before two different forums. And the risk is that you don't want to have two contradictory decisions, and so typically we'll suspend one or the other of the processes until the first complaint is dealt with, and then usually it turns out that the second complaint is also dealt with as well. I don't know if that's probably the standard procedure in other provinces as well.
Well, practically speaking, if we're talking about Ontario or the federal human rights system, if somebody has a valid claim for loss of earnings benefits because of workplace harassment, they're unable to work because of workplace harassment, and as a result has suffered a loss of income. And if they have a valid claim with the workers' comp based on the fact that it is a work-related injury, like if they are able to claim loss of earnings benefits through that, it is infinitely faster than getting damages from either the Human Rights Tribunal of Ontario or through the federal human rights process. Both of those processes right now have tremendous backlogs as a result of the volume of complaints and as a result of challenges posed by COVID and because of resource challenges. So just practically speaking, by the time if somebody is to claim in both forums, by the time the human rights complaint is adjudicated, the employer's lawyer should be able to make submissions regarding double recovery and be able to take into account of any loss of earnings benefits received from workers' comp in assessing damages.
Well, and many workers' comp legislations provide for a bar that would prevent employees from bringing claims for matters that are covered under the legislation. So there may actually be a bar to bring the human rights complaint, depending on what they're actually seeking damages for. So with that, thank you so much to everybody for joining us, and particularly to those who have managed to stick with us to the end. We hope to see you next week at the final 2021 Year in Review webinar on labor relations. And thank you to both Bonny and Rhonda for their presentations today. Have a good day.